Okay, I'd like to call the first meeting of the Rules, Charter Review, Ethics, and Council Operations Committee to order. Today's subject will be ethics. The clerk, who will be Joe Nani today, will be the clerk pro tem. If the clerk will please call the roll.
Connolly. Brady.
Present.
Simon. Not here. And that's it. Oh, I'm sorry, Greenspan. Sorry.
Since we have no minutes to approve, we'll just move right into the new business. And what I wanted to discuss initially was the memo that I sent to the committee members, which just basically outlined the process to which I've outlined, and obviously it's open for discussion, for us to come up with an actual ethics ordinance. I tried to be as direct and to the point as possible, but also, the calendar will dictate and the workload will dictate if we need to modify this in any way. So we're not necessarily, I guess what I'm saying is the process and the timeline is subject to discussion. But fundamentally, what I wanted to try to do was create this 8-phase approach. And the first phase and the second phase are the two that we'll address today. And then next week we'll move down the list. But I'll review those phases right now. Phase 1 will be to identify the reference materials. And I think we need to be cognizant of the fact that we are all bound by the Ohio ethics laws, the foundation to which we operate from. We cannot weaken any of the Ohio ethics laws. We can accept them or we can strengthen them, but we cannot weaken them. The other document that I'd like us to consider as we move forward is the proposed Code of Ethics that the Transition Advisory Group brought forward, as well as the current Cuyahoga County local, what I refer to as local Code of Ethics, which is Section 3 of the Employee Handbook, as well as a proposed ethics ordinance that I brought forward back in March, just as a reference source for us to use as a document that was successfully passed outside of Cuyahoga County. So those will be the 4 reference materials, and I believe each of you were forwarded an email, and Joe has presented all of you with the hard copy today for us to discuss. The second phase would be to identify the best practice definitions and terms. I don't believe we can properly address an ethics ordinance unless at least we have a fundamental understanding as to what terms and definitions we're going to use in creating these ordinances, or this ordinance, or in the policies of the ordinance. So those are the 2 areas today I'd like to address: identifying and coming to consensus that that's what we want to use as our reference materials. It doesn't preclude us from using other materials, but at least we start from there. This process today is going to be very tedious. I just want to put everybody on notice with that, because we will be laying the foundation, and oftentimes that's not a quick process, but I believe it is the most prudent and a very worthwhile endeavor for us to undertake. Phases 3 and 4, which we will address next week, will be to compare and contrast the state law with the reference materials, and also to identify any possible local amendments, not amendments to the state law per se, but additions that we wish to add to our ethics ordinance, once again using the reference materials or any other concepts that may be out there. The 5th phase would be to form a constituent subcommittee, which the members of this committee would not necessarily be obligated to attend, but obviously are welcome, as are all members of council and the public, but to engage the public in what we're in creating this ordinance, and talk to some stakeholders who have experience in ethics reform. It is my expectation that after we've identified the policies and procedures, the definitions, and so forth as to what we're going to do, that we'll be able to prepare a draft ordinance. I have spoken with the State Ethics Commission, and they are amenable to reviewing before we adopt our ethics ordinance for compliance with state law, to make sure that we are not in violation, our proposal is not in violation of any state laws, and it also provides a good checks and balances for us to ensure that we adopt an ordinance that is free from conflict or free from any interest or influence. The 7th phase would be to hold a public hearing to engage the public in general on the ethics ordinance, so that folks understand what we're doing and what we're trying to do. We'll publish the draft ordinance on the website so people can pull it, the public can pull it down. And then it's my expectation that the 8th phase, which would be to have a version available and distributed to council for review by February 10th. It will then be discussed and placed on the work session agenda for February 15th. And I anticipate the first reading February 22nd, second reading March 8th, and final reading on March 22nd, which is the day the current ethics ordinance would expire. So, and all this is spelled out in the memo that I sent to you, but I just wanted to review it. Are there any questions about this timeline? I know, Dale, you had a question earlier about maybe accelerating part of this.
The question I would have would simply be to try to produce an earlier draft at perhaps an earlier stage, so that we have a more extended committee process subsequent to introduction. However, when you're talking February 8th, well, that's pretty early. I didn't recall it as being that early, so that's pretty early.
Any other comments? Okay, we'll move forward real quick, though. I kind of prepared a statement. I just want to read it, which kind of outlines a little bit of a philosophy here, and I want to get feedback from my committee members. And I'll just read this. It's better for me to read this sometimes than try to paraphrase it, but Cuyahoga County is bound by the Ohio Ethics Law. This committee is charged with initially compiling, reviewing, and recommending to the full county council for adoption a county ethics ordinance. This ordinance will, at a minimum, be consistent with and, where possible, strengthen the state law. Secondarily, we will meet as needed to review and recommend amendments to the then adopted County Code of Ethics. The Ohio Ethics Law is designed to protect and promote the general public interest and to support confidence, prohibiting biased public expenditures and decision-making conflicts of interest in public officials and, for that matter, anyone who represents the county. The county's ethics law will support the state's mission, but will also provide local amendments where possible and applicable to promote an ethical culture consistent with the direction that we want our county to move towards. Cuyahoga County has an inspector general and a department to support the duties of such an office. This office should serve and perform locally in theory and in practice in the same fashion as the Ohio Ethics Commission and perform the 5 statutory duties currently performed by that commission. Those duties are to advise, educate, provide. They actually do financial disclosure assistance. Will provide that assistance to investigate and assist the county council in consideration of ethical litigation. Ethics-related legislation. It is our role to create ordinances, policies, and procedures to which the Inspector General shall enforce. I'd recommend that this committee focus on the creation of policies, activities, and actions of the ethics law for the county, and that when we address the Inspector General ordinance, we will then focus on enforcement, investigation, review boards, commissions, committees, etc. That's kind of just a brief overview, as at least to my perception, as to how this committee and what the charge of this committee will be, and that we create the ordinance and the policies, and the Inspector General shall investigate and enforce. I want to get your feedback on that.
Maybe I'm just being technical, but I think that the Inspector General investigates. I think only the county executive can enforce any discipline on personnel.
That's correct. It would depend on the infraction. If the infraction can be handled locally, then yes, then the executive or his or her department heads. If it's a criminal matter, then they would.
But any disciplinary matter within the system is under the charge of the county executive. Right.
And we haven't gotten that far as to get into the Inspector General ordinance.
We don't anticipate that any of our employees will get involved in criminal activities, so we don't have to worry about that.
I would hope not. Yes.
My suggestion would be that going in, we should decide if we're going to create an ethics board. in addition to having an inspector general, because they might play somewhat different roles. And if we do, to have a clear understanding of how the inspector general and the ethics board complement each other, and decide what each of their functions would be. I think we should do that rather than relying on the inspector general at the outset and then trying to bring in an ethics board later as an overlay. I think we should try to conceive of the two as a system as part of this ordinance we pass, or else decide that we're not going to have an ethics board and do it all through the inspector general. But we should be intentional about conceptualizing that.
Okay, I would agree with that. What I'd like to do is to stay focused on today's agenda and be clear on the on coming up with the definitions and agreeing that the resource materials we're going to use. Later on the agenda, there's a general discussion topic. I've already written that down, Dale. So, Councilman Miller. So next meeting, I'd like to get into some of these really policy-driven issues. But at least today, let's build the foundation. And one thing I failed to do was to appoint Councilmember Brady as the secretary for today's meeting. So Councilman Brady will serve as the secretary for today's proceedings.
You want to mark the presence of the other council members?
Yes.
I'd like to call the roll for Sonny Simon. Okay, and the other members that are present, I don't know the protocol here, that are not on the committee, do we call their roll or just acknowledge that they're here? Okay, and Pernell Jones and Chuck Germana are here.
Okay, now as we move forward into identifying the resource materials, I'm just going to call by consensus here at this point. Are we in agreement that these 4 documents would be the documents we would initially use as documents to begin the definition process of creating the ordinance?
Yes.
Sure. They are and each of you should have a printed copy of these, the Ohio Ethics Law and Related Statutes, the document that's titled Section 3 Code of Ethics, the proposed Cuyahoga County Code of Ethics as provided by the Ethics work group from the Transition Advisory Group, and the what actually looks like an ordinance, and it's an ordinance to establish in Cuyahoga County, Ohio, a commitment to ethical practices to provide procedures and implementation and enforcement and for other purposes, which is the last document there. It's got kind of my website stamped all across it. That's the Greenspan version. So I appreciate that. So those would be the 4 documents, although we're not limited to those. So if within next week somebody comes up and says, hey, I'd like to present these or alter the definitions, we'll bring those up to discuss. But at least this gives us a starting point to create the definitions today. Yes, Mr. Councilman Miller.
Mr. Chairman and my colleagues, the one thing that I would add to that would be the Ohio Administrative Code sections, which were written to interpret some of the state law on ethics, and some of these sections, for example, found their way almost word for word into the county policies and procedures. So we should include that administrative code language as a source document along with the revised code itself.
Mr. Miller refers to 123:1-4602 of the Ohio Administrative Code. I have a copy if anyone wants one.
Correct, and I believe we would further that to Chapter 102-1 through 11-03. Correct? Are those? So we'll be able to we'll use those documents, and like I said, any other documents. The intent here is to come up with the best practices in determining an ethics ordinance. I think. Were there any other comments? I thought. Councilmember Simon, did you?
Pardon me.
Did you have any other? Oh, I thought I saw. I think the best way for us to handle this right now is if we assign, because there are so many documents here, to assign each of us a document as we go through the definitions, and just start with one document and work our way through. Discuss each of the items and come to a consensus as to what the definition that we will use in the actual ethics ordinance will be. Are we in agreement with that process? Okay, great. If you don't mind, I'd like to facilitate this, so I'll just assign these out. Dale, would you take the Ohio ethics law? And I believe each of you have that in there. Dan, would you take the proposed Cuyahoga County Code of Ethics, which is this document? And then Ellen, would you take the, I'm sorry, Council President Conley, I apologize for the lack of protocol. Would you please, well, I'll tell you what, why don't we do this? Councilmember Simon, would you take the ordinance that I brought forward? And then Council President Conley, if you would work on the administrative codes.
This is the one from the,
That's the transition.
okay, which one do you want?
So as I said, this is going to be a tedious process, so I appreciate everyone's patience as we go through it. So Councilmember Simon, why don't we start with you, since I know the definitions are right there in the front. And once we compile these definitions, and we'll go through and note them, our clerk will put them into a definition format as we begin the process of identifying the ordinance, get it over to the Director of Law to compile into actual ordinance format, and then these will all once again be vetted through the Ohio Ethics Commission for compliance.
What exactly are we individually doing with these particular definitions? Reviewing them and seeing if they're consistent?
No. What the intent here is to identify. So, for example, under the document you're looking at on the first page, where the definition of associated, we'll read the definition, we'll read it out loud, then we'll discuss it, determine if that's the definition we want to adopt. If we want to modify it or change it in any way, then we can at that time.
And we, at the same time, maybe looking at how the definition is used in the other context also, or it probably would make sense for us if we all have a document that says associated to maybe see how it, part of the discussion might be different or similar.
I would agree, and so I would ask each of you to look and see if some of these definitions I've looked are not in each document. Some of them may be hard to identify because they're not laid out in such a way that they're all on one document or even in alphabetical order. So if we come across one now and we come to consensus on it, and it turns out that in a subsequent discussion it's determined that definition comes up, we'll go back and revisit it. This is like I said, this is the tedious process of what we have to do. This is not the policy setting, but this is the foundation for that. So as you have your documents that you're assigned, if you come across a definition that we're going to bring forward or that's being discussed, bring it up, we'll cross-reference it, we'll discuss it, but at the end we should come up with the consensus definition as to what we're going to include in the ordinance.
You want me to start with definition associated and read it? Is that
correct? Just because there are members of the public here that might not, and we want it read into the record exactly what we're going to be discussing.
Okay. So we're beginning with Councilman Greenspan's ordinance, proposed language, Section 1-100 definitions. And the first word to be defined is associated. And when used with reference to a business or an organization, includes any business or organization in which a public servant or a public servant's partner in interest is a director, officer, or trustee, or owns or controls directly or indirectly and severally or in the aggregate at least 5% of the outstanding equity, or any business or organization in which a public servant or a partner in interest has a % interest. Part of the, your stamp goes over these words, so is that correct?
The last word was personal interest.
Personal, okay. So that's the proposed definition of associated.
Mr. Morales isn't here. I believe that the county, that the state definition of as we get into interest, and we'll talk about it, is 10%. So this would actually strengthen, which we can do, strengthen the state ethics law. Is there any discussion on this item, at least as it was read?
Mr. Chairman? Yes, sir. The state definition of an interest that I saw also has it at 5%. 5%.
Okay, very good. It's then 5%. Then I stand corrected. Okay, if there's no further discussion, then are we in consensus that associated would be the definition applied in the ethics ordinance in our proposal as it was read?
I guess I don't have enough understanding of how this impacts and relates to the Ohio Ethics Code. You said it was a 10%. Is that the difference?
Mistaken. It is 5%.
Consistently 5%. Okay.
Would also occur to me that we might not know what all terms need to be defined until we see the whole thing. I think it's going to be hard to do it in the abstract.
What I'm confused about is, the statute, Section 124, talks about unclassified and classified staff. Are we drawing a distinction there?
When we address that point, that definition, yes. Okay. That's where the administrative code section will come into play in defining and coming up with the definition. Correct. So that as we write the ordinances or as the policies are brought forward, when the term classified, as an example, is addressed, it will be defined in the ordinance itself.
Because what the general statute is 124.57, which is a prohibition against partisan political activity. And then it's further clarified in the administrative code, the one I read before, whatever it was, 124, subsection, whatever, 57, whatever. So what we're going to be doing is redefining the state statute for the county. Is that correct? Is that what our process is going to be?
What we're doing is we're identifying the terms and the definitions that will be in our ordinance. So, for example, that the associated here is more business related as far as equity interest and things like that. What you're talking about is a state statute relating to what a definition of a classified or unclassified employee is. That will be incorporated as a definition when we get to it in our ordinance.
Mr. Chairman.
Yes, Councilman Brady.
Thank you, Mr. Chairman. I will admit that I'm having a hard time following this. And I would only suggest that since the chairman person has thought this through and is more familiar with the different materials that you've decided to use, that this would be clearer for this particular council person if the chairman would lead the discussion and focus on the areas, focus on what it is that you're trying to clarify, and maybe it's just me, but I'm having a hard time looking at several different documents at once and trying to determine what it is I'm trying to make some judgment about.
Sure, that's not a problem. I'll be glad to take the lead and read the definitions and then lead the discussion as to how we should move forward with those. That's fine. But understand the overall process here, we have to come up with the definitions in order before we can even create the policy. Because when we start talking about a classified or unclassified employee, we need to understand what that is. So we need to define it first. And all I'm suggesting that we do here is take previously adopted language, incorporate it into a glossary or a term, definition and terms, so that when the next phase or next phases 3 and 4, when we start creating the actual policies, reviewing and adopting, the outline, the foundation's already been done.
Mr. Chair?
Yeah, yes, Councilmember Simon.
I just want to state as part of this Rules Committee that I am on loan right now from Domestic Relations Court. The judge gave me a pass, so I might have to run back there to conclude business and come back. But from my perspective, if I just would offer this, that we passed a 90-day adoption of the Ohio ethics law, correct? And maybe that's a place to begin about what did we adopt and what is it maybe perhaps with definitions or policy that we like or don't like, and then move that into your proposal and see how that relates, I guess.
Well, I didn't mean to start with this one. I just started left to right.
Maybe what we should start with is what we actually adopted and say this is what we have, this is what we have right now, and let's understand what we have and maybe then try to move into what we would like to change or to retain. That's just a suggestion.
That's a fair statement. So we'll start with like I said, I just started left to right. My left to right, I didn't mean to start in any other particular order. Yes, Councilman Germano?
Mr. Chairman, thank you for allowing me to sit here and on your committee meeting. Since this is the first actual committee meeting that I've attended, what's going to be the protocol for non-committee members to address the chair?
I believe that's at the discretion of the chair. My protocol will be to allow council members to freely express their opinions and provide input. Obviously, when it comes time to vote, only the members who are on the panel on the board will vote. But I believe that'll be left up to each committee chairman. Is that correct, Mr. Miller?
Mr. Chairman and my colleagues, the rules state that any member of council who's not a member of a particular committee may attend, sit at the committee table, and participate in all the discussion, just not vote or offer motions.
So that's the protocol.
Mr. Chairman, today I actually had someone sent to me a couple different sections of the Ohio Administrative Code that I think pertains when we're talking about unclassified and classified service. And I didn't get the opportunity to make copies for everyone, but just for the input of 12411 unclassified service, classified service of the Ohio Revised Code.
Mr. Germain, let me just to stop you here because I know you missed the beginning part of the meeting, but what we're intending to do here is outline a process to which we will create an ethics ordinance. Today's focus will be on not any specific issue, such as the issue I know that you're going to speak of, which is the party affiliation and employment status. What we'll do at the end of this meeting is identify those issues which are being brought to our attention, and at the next meeting on next Tuesday, we'll be able to address those as they relate to the current ordinance that we've adopted.
Mr. Chairman, what I just had in mind was just to bring to your attention these two parts that you might want to have as reference documents. The 12411 and the 123-1-5-01. And then we'll have copies made for everyone. I just wanted to, as a reference information.
Great, well, thank you. Okay, what we'll do is we'll switch documents that we're going to reference in order to create the definitions, and we'll move to the Ohio ethics law that we're currently operating under. And once again, we can leave these as they are. These are the current laws that we're operating under, or we can strengthen them. That will be our discretion. So right now I'm in the Ohio ethics law, chapter 102.01, and we'll just start with the words of compensation. Once again, we can vote to leave these as they are or to strengthen them. Compensation, as compensation is defined, means money, things of value, or financial benefit. Compensation does not include reimbursement for actual and necessary expenses incurred in the performance of official duties. That is the definition. Is there any discussion on that definition? Okay. Hearing none, then what we'll do is we'll do a reverse vote. If anyone has any objection to it, voice their objection. If not, we will assume that the definition will stand as our definition. Number 2, public official or employee means any person who is elected or appointed to an office or is an employee of any public agency. Public official or employee does not include a person elected or appointed to office or of precinct, ward, or district committee member under Section 3517.03 of the Revised Code, any presidential elector or any delegate of a national convention. Public official or employee does not include a person who is a teacher, instructor, professor, or any kind of educator whose position does not involve the performance of or authority to perform administrative or supervisory functions. Is there any discussion about this definition? Any opposition? Okay, this will then become a definition to be included in the ordinance. Public agency means the General Assembly, all courts, any department, division, institution, board, commission, authority, bureau, or other instrumentality of the state, a county, city, village, or township, the 5-state retirement system, or any governmental entity. Public agency does not include a department, division, institution, board, commission, authority, or any other instrumentality of the state or a county, municipal corporation, township, or other governmental entity that functions exclusively for cultural, educational, historical, humanitarian, advisory, or research purposes that does not expend more than $10,000 per calendar year, excluding salaries and wages of employees, and whose members are uncompensated. Any discussion on this definition?
Mr. Chair, the only discussion I would like to maybe have is that these definitions have already been adopted, but I'm unclear at this point in the context for us to preclude revisiting these definitions until we get into how actually they're going to apply and interact with what we're actually doing. I think it's difficult to say, okay, we adopt this, or we're going to keep it as it is, or we want to strengthen it. I think it might be helpful if we just go through the actual, see how these words are used to see if we want to revisit the definition or we've already adopted this. This is what we have. So your threshold question is, do we want to strengthen these? And I don't think I'm in a position right now to say I want to strengthen it or do anything until I see how is that going to actually come through the actual ordinance. But that's just me.
Mr. Chairman, to the councilwoman, are you saying that that you see this as a process of just reviewing these documents rather than us as a committee actually affirmatively saying that we have made a final decision on the language that is in front of us?
Yes.
Mr. Miller?
Mr. Chairman, this particular definition refers to the state, counties, cities, villages, townships, state retirement systems, and so on. It seems that we could probably write a definition that would be more county specific, but would be totally consistent.
Do you have anything to offer to that right now, or do you want to bring it forward at the next meeting?
Mr. Chairman, I would not try to write it on the fly.
Okay, very good. Let me try to address Councilmember Simon's point, and I understand it. I'm trying to. At some point, we will need to identify and define the foundation for our ordinance, which I perceive to be these definitions. I know, as I stated, I know this is a tedious process to go through. But at least, we've adopted these definitions are ours. We own them. But I'm not sure how frequently we've reviewed them in this level of detail.
I just offered my opinion, but keep going with these individual definitions. The only caution I wanted to put out is not to preclude revisiting these definitions instead of just saying, do we agree with this and adopt it? Yes. But perhaps maybe through this process, we might want to come back and say, oh, maybe that should be changed a little bit. That's all I'm asking.
And I completely agree with that. And that's my initial statement was, as we go through this, nothing is final until we basically hand it over to until we vote on it effectively. I mean, it could come through one of the readings and we determine that we need to change a definition as a result of a circumstance that Councilman Germana just brought up. Something that comes to light down the road. But like I said, I'm just firmly committed to at least building the foundation, and I believe that as we move forward, at least there's no misinterpretation as to what a definition may be. We may want to strengthen it later. At least at this point, going through the ethics law, I want us to understand what statutorily, in my opinion, and talking with the Ohio Ethics Commission today, we can't change this as far as weakening it. So I want us to at least understand what we have and what we're working with. If anything, this committee should be the group that's has an intimate knowledge of the ethics laws, since we're impaneled with coming up with the ordinance itself. That's why I want to go through this tedious process. Other committees may not have to. I know we met on rules. We did not a similar thing, but we basically understand what the rules of council are and some of the terminology that we'll be utilizing as we go through that process. But this is, for example, when we get to immediate family, I have an expanded definition which is the next item that I'd like to modify as it relates to immediate family.
Mr. Chairman, I'd like to raise a pretty broad issue that relates to definition C, the one that I just read on public agency, and it's the question of whether in writing the ethics law for Cuyahoga County, are we going to be writing an ethics law that only applies narrowly to Cuyahoga County government? Or are we going to be writing an ethics law that also applies to the other political subdivisions that operate within the county? My sense is that it would be the former rather than the latter, particularly because the charter states that in any area where county powers and municipal powers might conflict, that municipal powers would carry. But I want to be clear that because that would affect how this definition is written and a lot of other things. So I think it's worthy of a little bit of discussion.
It's my understanding that we're writing the county's ethics ordinance, not municipal, not those that would be applicable to municipalities. I can tell you that I've been approached by a couple of municipalities who want to use this as possibly a reformation or actually an ethics ordinance that they wish to adopt in their municipalities. But our charge is to write the county's ethics ordinance. So as you go through and as you you step forward in rewriting this definition, I hope voluntarily, that you'll keep that in mind as you narrowly focus the discussion to be at the county level. President Conley, did you have a? No. Okay. So as it relates to, just moving through, as it relates to public agency, Councilmember Miller will come up and present at the next meeting a more narrowly focused definition as it relates to the county. Moving on to immediate family. Immediate family means a spouse residing in a person's household or any dependent children. There is a definition and I'd like to broaden this. I'd like some discussion on this. Let me try to find it here real quick. Immediate family on page 4 of 24 in the ordinance that I brought forward, and let me try to find it in the terms that the County Transition Advisory Group brought forward. Provides more language as to what is meant by immediate family. Let me try to identify it in this document.
I have it, Mr. Chair. Your definition? Did you want to?
Yes. I have that one. I was looking for the one and the other one, but I was actually looking in that one, correct? Yes. Yeah, that one. Councilmember Simon, do you want to go ahead and read that definition?
Sure. Immediate family means a public servant's spouse, children, grandchildren, parents, parents-in-law, grandparents, grandparents-in-law, sisters, sister-in-law, brothers, brother-in-law, sons-in-law, daughters-in-law, nieces, nephews, aunts, or uncles, whether by marriage, lineal descent, or adoption.
So this, to me, in my understanding of how we define immediate family, obviously this will have impact going forward on various ordinances, but I would make, and let me look here, and basically in the ordinance proposed by the Transition Advisory Group, almost mirrors the state ethics law in that it says spouse or domestic partner, children, parents, or step equivalents. That's their definition. We may want to add the language that's not in either one of these, which may be which we may want to add is domestic partner. So I would recommend that we adopt for immediate family kind of a hybrid of the three. And Director of Law Morales is here, so if you see us step out of line, and please feel free to speak up. But I would like to expand the immediate family definition to be just as Councilmember Simon added, but read out loud, but also add the domestic partner provision that was in the Transition Advisory Group into the definition of immediate family. Is there any discussion on that? Do you think?
Well, Mr. Chairman, I guess this is the beginning of a discussion. I have no way. I mean, I've heard what Councilwoman Simon read, but I have no way of at this point of judging what the impact of that kind of language is on any kind of a practical application of ethics laws. So I'm certainly not at any point where I'm willing to adopt such a broad range of ethics regulations because I don't yet understand what the impact of such a proposal is.
Mr. Morales, were you reaching for your microphone?
I was just going to say we don't use domestic partner in our definitions of immediate family generally that I can recall in any current county policy.
Okay.
Just for your information.
Mr.
Not for the purpose of any human resources.
Well, on this point,
policy or procedure.
on this point, if we begin to discuss domestic partnerships in terms of law, ethics laws, then we are certainly opening up the discussion in a much broader sense of what a domestic partner is, and then therefore a whole host of issues that might apply. So I would not be trying to suggest what my opinion is on these issues, but rather that this is a broad issue probably that there would need to be significant discussion about its impact on the county and its practical, how practical it might be or not be.
Well, that's a great point, and I was not aware that if the county doesn't currently define domestic partner, then I would be willing to remove that from my proposal at this time. As it relates to the other classifications, this is going to be somewhat, and I've lived through this once before. This is going to be somewhat of a painful process, and the decisions we make should not be based on any current employees or current status of any county employee. This has to be looked at as basically a 50-year or 100-year document. And the policies that we set forth today should be such that it doesn't take into account any prejudice towards any current employees.
Mr. Chair?
Yes.
That's not what I heard Councilman Brady articulate. I think, if I can, that's what I was articulating. It's very difficult in a vacuum, for me at least, to look at these definitions alone instead of having some practical understanding of how that's going to impact not the current situation, but even in 50 to 100 years, how is this definition of expansion going to impact the future? And that's what the difficulty I see is defining these things until we understand in the current context of what we adopted, Ohio Ethics Code, how that actually plays out. And I think that's what's missing for me is I don't do well with just looking at a definition. I need to see exactly what the implications are, how that's going to impact, not necessarily today, but how that's going to impact going forward, because I think that's what most of us are looking to. So I don't know how to do this. If this is the best way we can do it, we'll do it this way. I don't have an objection to that, but I have a hard time just saying I'm going to adopt this or that without going through the Ohio Ethics Law Code and just get a feel for how that's going to play out and these other definitions may play out.
Council President Conley.
I just have a concern. I'm trying to figure out what somebody's grandparents-in-law actually are. Is that like your spouses? Okay. We live in a society where people have less children and not so close. Some people don't even know brothers-in-laws and half sisters-in-law. And with juries, it's kind of like in some counties, if you walk past the courthouse, they won't let you in the jury because maybe you know something about the case. I think at some point you start stretching you stretch so far that people don't even know this person is like their ex-brother-in-law or something. That's the kind of the concept I think that Simon's saying. Let's kind of think about this. When you go so far, where are we stopping here?
I hear the conversation. I hear the argument. I don't have an issue with what's being said. And as this,
I'm just trying to throw this out as a concept. I'm not cast in stone on this yet, but I'm just kind of how far are we casting the net here?
Well, first of all, this ordinance that I'm pulling this definition from, I can tell you has already been vetted through the U.S. Department of Justice. It far exceeds the requirements of the state of Ohio. Insofar as determining these specific definitions, when we get into in-law relations, the intent as these ordinances evolve and as the policies evolve is to prevent any type of nepotism or cronyism from occurring. And so what will happen is if somebody unwillingly hires a person or is in their direct line of authority and they don't know it, that's one thing. But to intentionally hire an immediate family member that's determined to be intentionally hiring a family member, obviously that, as we read further even into the Ohio ethics law, is a prohibited activity when you get into nepotism.
Yeah, okay, that's well and good, but somebody may have a brother-in-law they don't even know, and the brother-in-law's got a son, and the kid applies for a job, and all of a sudden, this is somebody's brother-in-law's son. I think can you kind of stretch it so far that it's kind of beyond the pale. Like, for instance, is my nephew's wife prohibited from getting a job now under this?
That's a good question, but under this definition, that's not covered.
I may be closer to my first cousin, but my first cousin is not covered under this.
Mr. Chair, I guess what I'm not, and I understand this narrow discussion, but how does and maybe we discussed this and I missed it, our adoption of a code that differs from what the executive is going to adopt? I don't understand if right now the executive is going to pass Ohio ethics law and we do something differently, how is that practically going to play out at this county? Because we aren't not really having a broad ability to hire or to perform, but the executive has a different code than we have. How is it actually going to play out? And I guess that's maybe a threshold question for me, is if we expand this definition, but the executive doesn't, what happens?
Well, the fundamental ideal of a county council is we set the policy for the executive to administer. There will not be two sets of standards. There will be one standard. I look at Mr. Ivory there, and I'm sure Mr. Ivory is representing the executive who was invited to send either himself or a delegate to this meeting to participate. The Inspector General, when she comes on board, will be an active participant, as is the Human Resource Director and legal, to guide us as to what the policies are. We're not going to create these policies in a vacuum. the intent is to sit with the executive and make sure that he's in concurrence as much as possible with the ordinance, not only this ordinance, but I would suggest countywide with any ordinance that or policy that we set forth, that the executive, who's going to be the one who's going to be administering the policy through his administration, is in agreement with what we're doing here, at least in part or in whole. We will not come to consensus with everything that this council does with what the executive wants. However, we should work as closely as we can with the executive and the administration that that what we pass as a council, not necessarily this in particular, is at least consistent with what he wants to do. Just like when we had our first meeting at CSU and the definitions of where our authority starts and stops, where the executive starts and stops, and where buy-in occurs along the way, and where the consensus is built between the two branches of government is critical. And this is going to be an example of that. You bring up a good point. We may come up with an ethics ordinance that we present to the executive for him to opine on, and he may say, you know what, this definition is too broad, state law requires this, but at the same time, we need to put forward the best ordinance we think is going to be in the best interest for the county. I understand Council President Conley's concerns about not knowing who some family members very well may or may not be, but I believe that by adopting a broader definition of immediate family as an example would be prudent for us at this time, not only based on what's happened in the past, but also to make the county more cognizant of what the policy is going forward.
Mr. Chair, the only caveat I want to put here, and maybe not the only one, is that some of this is administrative also, that it's an administrative function to define the nepotism. Are we making a proposal? I mean, if we pass this, I understand we're going to be having conversations. So is what you're saying is we just want to propose what we would like the administration to adopt? Because
the administration will adopt what we pass, effectively. We set the policy for the county.
Mr. Chairman,
is that correct?
The charter authorizes the council to adopt an ethics policy by ordinance. So it's a specifically enumerated power of the council that's found in section Article 3 of the charter.
I understand that. So is this, whatever we pass, whether the executive buys it or not, is going to govern the administration of Ed Fitzgerald? Or do you believe that our executive will also have an individual administrative policy to which he would seek implementation?
If there was a separate policy, it would be no less stringent than what council has adopted. It could be that the executive could say, we'd like to enforce this in a more restrictive manner than council has even included in the ordinance. So it could be there could be a policy, the way that the ethics policy is implemented by the executive could be more restrictive in terms of of promoting ethical behavior, but certainly no less. And, sir, I need to correct myself. I am notified that there are a couple of areas in which domestic partner are referenced in the new policies and procedures manual: sick leave and funeral leave, and I believe one other.
Okay, thank you. Let me, real quick, I'll come to Chuck, but Councilmember Miller.
Mr. Chairman and my colleagues, I think this is the 21st century, and domestic partners should definitely be included. I think what's a very fundamental question is the very broad definition of immediate family that's in the Greenspan draft. To answer the council president's question, she asked about her nephew's wife. Well, as I read this language, it's very clear. It lists these things, including nieces, nephews, aunts, or uncles, and then it says whether by marriage, lineal descent, or adoption. So the nephew's wife would be a niece by marriage. So
by affinity or consanguinity is what the legal definition is.
What I'm saying is that definition to me sounds more like the extended family rather than the immediate family, and I think we need to give some careful thought as to how far do we need to go in terms of what becomes more of a shirt-tail relative as opposed to an immediate family relative that we need to be concerned about.
Then let me, Mr. Germain, and then I've got a concept following up on Councilmember Miller's statement.
Thank you, Mr. Chairman. Great minds think alike. This is exactly what I was going to offer. I agree that the Greenspan definition of family we should have a category for full family, but immediate family is not this. So maybe there should be two classes: immediate family, and then family in general. Just to give an example, we might want to have a higher standard for immediate family than in general. But as an example, if we had a large contract that the county was going to pass, or if somebody was related in general, I think the county council person should recuse themselves from voting, because it would be somebody of family in general. And certainly if it was immediate family, then it would be no question. But that's what I want to offer. I think there should be two levels of family.
And I would agree with that. And so what I would suggest is that let's look at the immediate family definition that's outlined in the current state ethics law to be spouse residing in a person's household or any dependent children. So we would adopt that state language as our immediate family language, and extended family, or instead of extended family, just family, would be the definition of spouse, children, grandchildren, parents, and so forth, all the way down. Does that seem like
Mr. Greenspan, I'd just like to point out this immediate family means a spouse residing in the person's household. So in other words, under this definition, if I have an estranged spouse who's not living in my household, that person is not in my immediate family.
Let me ask Mr. Morales, would we be able to remove, so you're saying possibly remove the language residing in a person's household. Can we remove that from the state? Is that strengthening? That would be strengthening, wouldn't it?
Yeah, absolutely.
Okay.
It would be.
So maybe a suggestion would be that immediate family is defined as a spouse and any dependent children.
And, Mr. Chair, domestic partner, because I think a domestic partner is equivalent in some cases to spouse, and if we want to be, I think maybe that should go there.
That's a good point. I have a question to Mr. Morales. Does the county currently have a definition for domestic partner?
I will have to check into that for
Okay.
you. I have not seen that.
Okay. So I would be amenable to have the definition of immediate family mean a spouse, domestic partner. Writing this down.
If the county doesn't have a definition, I will get you one.
Okay, perfect. And any dependent children. So we would be adding domestic partner, removing residing in the person's household to take care of the estranged spouse concept.
Sir,
And that would be immediate family. Yes, sir.
I apologize for the interruption. I am told, and I note that there is no reference to stepchildren either. Just for your information.
Yeah, in the dependent children or stepchildren. Okay, so we would add that in there as well. So I'll read the definition as I for immediate family means a spouse, domestic partner, and any child is it child, children, or stepchildren, stepchild? How do we properly word that?
Stepchildren.
Stepchildren would be fine.
Mr. Chairman, in the proposed Code of Ethics by the transition, they have step equivalents is the verbiage they use. Mr.
Morales, is there an issue with us using that definition? Well, that might move into step that may move more into the family definition, correct? Step aunts, step uncles, step grandparents, if we do equivalence.
Yeah, I'm not familiar with the usage of, quote, step equivalents.
Okay.
So
Mr. Chairman.
I think
sir.
that's ambiguous language.
Okay.
Myself
We'll
would
be more
recommend against
specific then.
Mr.
Yes, sir.
Chairman, whatever suggestions for language, even if we were to find consensus about it, it would seem to me that it would be necessary that that our work be gone over by the city's law department.
Oh, absolutely.
Because we cannot, and sitting here in this amount of time, fathom the legal definitions of, particularly if something is as unusual or unique as this. On domestic partnerships, I agree that the language should be included. I think that's also, though, as I was alluding to before, part of a broader discussion. I know the county, does have policies in this regard, but there are also other areas of county policy that this will inevitably lead to discussion of. So, be aware, very much aware of what you're proposing, because if domestic partnership definitions apply to ethics laws, then it would seem to me that would certainly give strength to domestic partnership being applied to other areas of county policy as well. I'm not suggesting what that policy should be, only that we're bumping up against it. Finally, on the second part of the discussion, outside the immediate family, and I respect what you're, I think, trying to do. I have instinctively a more conservative, I'll use that word to describe it, a more conservative view of this, based mostly on my sense of caution about where what we're doing, strays from or is different from state law, and not an unwillingness, but a general sense of cautiousness about straying from state law, unless I'm very clear in my own mind precisely what we're talking about.
No, and I understand that, and I appreciate that, and understand the intent here is to put down what we want, okay? Then we'll vet it through Mr. Morales. Then we'll vet it through the State Ohio Ethics Commission. So the final document that comes back for us to vote on will be, in my mind, completely vetted both legally and through the Ohio Ethics Commission. So they may come back and say, just like you're saying, hey, you can't, this is not not this in particular, but they may say item X is not in compliant with state law, or Mr. Morales may come up before it even gets to the Ohio Ethics Commission and lets us know, hey, by the way, this is inconsistent, or you might want to reconsider wording it this way. What's your intent? So my feeling here is, let's put down what we want. Let's let the attorneys and the Ethics Commission vet it out and get back to us a document that is as close to what we want as possible. So let me go back to the original definition of immediate family, as we've discussed it here, and then we'll add the definition of family, which will be a little more broad, and then we'll ask Mr. Morales at a later, between now and next week, to come back to us with the domestic partner definition. Immediate family means a spouse, domestic partner, and any children or stepchildren. That basically is the definition. Is there any discussion, any further discussion, or are we ready to? Yes, Mr. Miller.
I would raise the issue of points 2 and 3 in the Greenspan definition on page 4 of 24. The second point raises the question of someone who receives more than half of their support from the person in question, and the third one raises the point of someone who's listed as a dependent under the Internal Revenue Service, presumably saying, well, if they filed them as a dependent on their taxes. So as a question that we should think about whether or not any of that should be included as immediate family.
Yes, Council President.
You neglected to use the term dependent, and that adjective, that adjective is very important, because a dependent child is certainly different than just a child.
I did not mean to leave that out. That was my mistake. You're 100% correct.
That goes to what Mr. Miller was talking about. Dependent is defined then by the section, the amount of income and how you declare in your income tax.
Correct. That was an unintentional omission. So I'll restate it. Immediate family means a spouse, domestic partner, and any dependent children or stepchildren. If we're in agreement that be the definition of immediate
Child and dependent stepchild.
Correct. Jody.
Mr. Chair,
Yes.
why do we just want to state dependent children? What happens when they're emancipated as other than dependent? If somebody's 25 versus 18 or 30, I just want to throw that out there. Does that change that it's still a child?
That would fall under the family definition, which we're about to do next. So
Extended family?
the extended family. So we may have a case, and I don't know of any off the top of my head, where we may want to limit a policy just to immediate family. And we could say immediate family and extended family, or family, whatever our next definition topic is. But at least it gives us some leeway to be able to delineate between the two.
Okay.
Yes, Mr. Miller.
I actually think my colleague, Ms. Simon, is onto something. I think that that a son or daughter is very close family, regardless of whether they're dependent or not, and I would think we would want to include that as immediate family, whether or not they're dependent.
Okay. Well, here's what we can do on that. We'll bring forward two definitions. If that's where we are and that's the only definitive line, we'll bring forward two definitions, and we'll just get a consensus as to which one to go with. One will have the word dependent left out, and the other will have it included. So I'll read the immediate family definition with the word dependent in there, and we can get we'll take a vote on this one, and then I'll read it without the word dependent in there, and we'll get a vote on that, and the winner, the most votes will be in the definitions. Immediate family means a spouse, domestic partner, and any dependent child or dependent stepchild. All in favor of that definition? Well, I guess Joe will call a roll.
Point clarification. So this will be the definition that we will use then in our ordinance. Okay.
Calling the roll for the definition, which includes dependent. Dale Miller.
No.
Ellen Connolly.
No.
Dan Brady.
No.
Sonny Simon.
No.
Dave Greenspan.
No. We'll call roll then for a definition without the word dependent.
Dale Miller.
Yes.
Ellen Connolly.
Yes.
Dan Brady. Yes. Sonny Simon.
Yes, with the caveat that this will be reviewed and can be looked at later.
Absolutely.
Dave Greenspan.
Could you pronounce my last name one more time, please?
Greenspan.
Yes. And to your point, Councilmember, everything will be reviewed for compliance. The next item we'll move into will be the definition of, we'll just leave the word as family. So family shall mean as outlined, and I guess, actually, I shouldn't say I guess. To Councilmember Miller's point, why don't we expand it to include the full definition? Was that your intent of paragraphs 1, 2, and 3? So I will read those.
I'm so sorry.
A public servant's, this will be family. A public servant, and let me just say this. We will leave out anything that's consistent, that's in the word immediate family from family, so that if we want to include the two, we can include the two by reference, immediate family and family. If we ever wanted to have a policy that just meant family, we didn't have to go back and revise the definition. So a public servant's, the family shall mean a public servant's grandchild, parents, parents-in-law, grandparents, grandparents-in-law, sister, sister-in-law, brother, brothers-in-law, sons-in-law, daughters-in-law, nieces, nephews, aunts, or uncles, whether by marriage, linear descent, or adoption. That will be the item number 1, following Councilmember Miller's suggestion that we add sections 2 and 3. A public servant's relative by marriage, linear descent, or adoption who receives directly or indirectly more than one half of his or her support from the public servant, or from whom the public servant receives directly or indirectly more than one half of his or her support. And the third item, an individual claimed by a public servant or public servant spouse as a dependent under the United States Internal Revenue Code. So that would be the full definition of family.
Mr. Chairman?
Yes, Councilmember.
A question. Immediate family, is the term to be used in a situation, say like if a family member wants to go to Metro Health and visit a loved one? Is that the context that this term might be used?
I'd have to defer to Mr. Morales. This is the state law's definition.
I'm trying to imagine an ordinance where the term is used, and I'm trying to imagine a situation. And the first thought that came to my mind was the county hospital. A person going to visit a sick loved one. Would this ordinance or
No, this would not be for that purpose. Right, that would be included in the definition of an immediate family in a sick leave policy. Right, is that what you're getting at? The usage of leave to visit someone in the hospital?
Right, that was my thought.
No,
the purpose you put forward was, did you say sick leave?
Yeah, that would not be this. So this would be a situation in which there were perhaps a provision in the ethics policy regarding a reporting relationship, or a hiring decision, or a other type of decision that benefited, that other type of decision that someone made in the course and scope of their employment that benefited a member of their family. So not
insurance benefits, sick leave. You used the term sick leave.
Yeah, it would not be that.
I'll come back to Mr. Germana, and Mr. Miller, then Ms. Simon.
Mr. Chairman, I just think under family, it should be a public servant's immediate family, and because the family is the immediate family and the definition that you said. I mean, if you leave the immediate family out of the definition of family, it really doesn't make much sense.
Well, the reason that it was left out was if there was an instance that we needed to include them, we would include the word immediate family in the ordinance itself or in the policy, immediate family and family. That way it would be inclusive. But if there was a situation where we wanted to exclude the immediate family, the definition of family would be the prominent language. Does that make sense, Mr. Germana?
Mr. Chairman, it doesn't make sense to me. The family generally is the expanded family. And if you're saying your immediate family is not part of your family,
Are you recommending maybe we say extended family? So we would have a definition of immediate family and extended family? Yeah, Mr. Miller.
Mr. Chairman, I would recommend under family in number 1, where it says a public servant spouse, I would add after that domestic partner. And I also think that if you do that, it would be clear that your definition of family, just as written, is going to include everybody that's in the immediate family. So that question then would not come up. If you say family, it would be a broad definition that would include everything that was in immediate family plus some additional.
Okay.
Well, under this, if I come and I'm a cousin under this definition, I'm not covered. there's thousands of cases and legal definitions for this stuff. I really think we're treading on dangerous territory here. I mean, I don't know if we're buying ourselves a lawsuit or what. I'm really kind of concerned about the avenue where we're going. We have a state law, and we've been functioning under state law. I just have some problem. We're buying ourselves some lawsuits here.
And I just want to add, if I can, Mr. Chair, to Councilman Jones' at least adoption of the consideration that Metro Health might pose a particular problem with these definitions. If, for example, there's a doctor or nurse who gets hired, it's technically not county, but is it close enough? And, that I think opens up a specific issue for us, Metro Health, maybe extending it.
My understanding of the policy is that the ordinance is that it is to be effective for all of the departments, agencies that fall under the authority of the county executive, and Metro Health is not one of those. Metro Health is a separate entity that is specifically excluded from the entities that fall under the authority of the county executive.
Mr. Chair, but when we look at the definition here of Ohio ethics, I want to be sure that this public agency does not include Metro, because that's what we have in front of us.
Where does it state that Metro is part of this ordinance?
It doesn't necessarily. I'm not saying it does say that. I'm just saying we have to be careful to look at public agency in its definition in the Ohio Code, that it may or may not impact Metro, for example.
I'll have to defer to Mr. Morales, but I believe, as he stated, this ordinance only applies to the.
I apologize. I am not seeing a definition of public agency in the draft ordinance. Did I came in late, perhaps I missed it.
I'm looking at the Ohio Ethics Code at the definition, right now we have that adopted as our ethics code. And I'm just articulating perhaps something we need to look closely at. If this is what's on the books right now, would this public agency definition exclude Metro or Tri-C or any of these other entities? That's all I'm saying.
This definition of public agency has not been adopted yet. We've deferred this one, and Councilmember Miller is going to come up and create a definition at the next meeting.
Chair, we adopted Ohio Ethics Code 2 weeks ago.
Talking about the current policy, that's correct.
And this is the definition that's included there, so I just want us to just be aware that they might have impact now, presently.
Yeah, I do understand the point that you're making, but council would not be able to supersede, to do anything that exceeds the authority granted to it by the charter. So I do see the point that you're making, and it certainly needs to be corrected in the adoption of the ordinance. But even if you did include language that you intended to apply to Metro Health, you would not be able to do so under the authority granted to you by the charter.
So it's a legal impossibility.
It would have no force and effect.
Okay, thanks.
So, for instance, under this ordinance, could a relative, could my sister get a job teaching at Tri-C?
Yes.
Okay, moving back to the original definition of family. Councilmember Germana, indicated a change from immediate to leave the word immediate family, but include and leave in spouse, children, and then there was another suggestion of adding domestic partner to that definition, and so I assume that the three sections then, I shouldn't assume, but I'll make the general statement that the three sections defined here under immediate family with the inclusion of domestic partner is the definition that council would like to include in the ordinance, at least for vetting purposes. Is there any further discussion on that? No. Okay. Anybody opposed to that? Okay. Then Mr. Nani, that'll be the definition for immediate family. This is probably, by the way, this exercise is the pure definition of making sausage here. So I appreciate everybody being patient going through this, but this is such a critical component to really moving this county in the right direction. I appreciate everybody's patience. Moving down into the definition of income. Yes, Mr. Miller.
Just so I'm clear on what we've decided, did we decide that we're going to have a definition of immediate family as you presented, but that we're not going to have a definition that's full family?
No, it will include full family and the words domestic partner.
Oh, okay. So we're going to have both.
Correct.
At least for starters.
Correct.
Okay.
That's correct. It will include the definition of immediate family will include the same provisions as. I'm sorry. It's we're going to have to terminology. Immediate family will be spouse, domestic partner, child, and stepchild. The definition of family, not immediate family. Family will be the one that I just read with spouse, children, domestic partner, grandchildren, parents, and so forth.
Just to be clear for my notes, that's the section that's in the Greenspan document.
Correct.
Okay.
Mr. Chairman.
Mr. Miller.
To Mr. Nani, it's the same as what's in the Greenspan draft with domestic partner added. Yes. Okay.
And the title will just be family, not immediate family. Or full family. Full family is fine. The next definition will be income, as defined. Includes gross income as defined and used in the Internal Revenue Code of 1986. It gives a statute. I'll read the 100 statute 2085 26 USC 1 as amended. Interest and dividends on obligations or securities of any state or any political subdivision or authority of any state or political subdivision, and interest or dividend on obligations of any authority, commission, or instrumentality of the United States. This is, as I just read it, is the current state ordinance or state law. I don't believe that there are any further. I'm looking at the two other documents. I don't see any further definition for income. So that, unless there are changes, that's the definition before us. Any discussion? Yes, Mr. Miller.
Does this definition say that if you receive income on foreign bonds or through foreign corporations, that doesn't count as income for purposes of our ethics code?
Yeah, it probably is included in the IRS code. I don't know that for a fact. Is there language you wish to add to that? Or were you just asking just a point of information?
The 16th Amendment says income from whatever source derived. That covers everything.
Okay. Councilman Miller, did you?
I would certainly want those foreign sources included if they're not already embedded in the definition.
They're already. Can we ask Mr. Morales to look into that specific point? As far as to the question that Mr. Miller is posing is, can we include foreign income in the definition of income? I'm just unfamiliar with what that code section actually reads as a definition of income.
I just do whatever TurboTax tells me to pay.
Okay, so any further discussion on this point? None? Okay, so any opposition to this point, to this definition? Okay, hearing none, that definition then shall be included as income. As we move down into, and we read further into this, it looks like the next definition that we come across is the Appropriate Ethics Commission. I'll go ahead and read that. Except as otherwise provided in Division A of Section 102.08 of the revised code, quote, appropriate ethics commission, end quote, means for for matters relating to members of the General Assembly, employees of the General Assembly, employees of Legislative Service Commission, and candidates for office to this is a General Assembly provision. The next provision relates to the judicial officers, and the third relates to anybody on the Ohio Ethics Commission. This is not applicable to us. We can, Mr. Morales, can we remove this from our ethics ordinance?
Yes.
We can. Or then I would recommend, because it's not applicable, that it not be included in our ethics ordinance. Is there any discussion? Obviously, our ethics ordinance, the foundation is a state ethics ordinance, so we would still be bound to this, but it just might not be stated in our ethics ordinance per se. Any discussion? So the recommendation is we remove Section F from the county's ethics ordinance because it just doesn't apply. Any discussion? Mr. Miller?
I think later on, when we see if we're going to create an ethics board, I think that the same things that are referred here to the appropriate ethics commission would generally be referred to the ethics board, and we would need to decide at that time whether there's anything that would need to be referred to the Ohio Ethics Commission as opposed to our ethics board. But if our ethics board is well created, that probably would not be necessary.
Okay. Point well taken. The next item has to do with the definition of anything of value. Anything of value has the same meaning as provided in Section 1.03 of the revised code and includes but not limited to contribution as defined by Section 3517.01 of the revised code. All right, anything of value. Let's refer to our other two documents and see if there's a provision in there relating to value. We will get into gifts later. This has nothing to do with gifts. This is just determining the definition of anything of value. I'm unaware. Has anybody else found anything in the documents relating to value?
Mr. Chairman,
Mr. Germana?
in the Greenspan, page 7 of 24, would you like me to read that?
Please.
Item 14, anything of value if the payment, gift, or other transfer of value is unrelated to and does not arise from the recipient's holding or having held a public position, and if the activity or on occasion for which it is given does not involve the use of the county's time, equipment, facilities, supplies, staff, or any other resources which is not available to the general public.
Thank you.
7 of 20.
In the transition advisory group's definition, they say their reference is see gift. Gift is defined, here we go, anything of value, including but not limited to money, goods, future employment, interest in realty, payments, loans, and services. And they also refer to see honorarium, which is I'm on page 13 of the transition advisory group's document. Payment of money or anything of value directly or indirectly to an elected or appointed official or employee or to any other person on his or her behalf as considered for speech, a presentation, or a written document that relates to the official or employee's county position. So that's the definition of an honorarium. So in the transition advisory group, if we look at gift and honorarium, honorarium defines the actual activity. Gift would define anything of value. So as we're considering these, we actually have three definitions to look at. Yes,
Mr. Chairman, I actually stand corrected because as I'm looking at what I read was item 14, anything of value, but actually that is just one subset of personal benefit.
Okay.
Your personal benefit really, in its entirety, probably is very inclusive of anything of value, because
Okay.
it talks about payment, fees, unauthorized reimbursement. If you look at page 6 of 24, and it actually goes through to the middle of page 7 of 24, personal benefit probably is a very expanded definition of anything of value.
Well, let me ask this. That's a good point. Maybe in looking at this, the personal benefit provision should be included in the definitions, but maybe anything of value is already defined by IRS, by revised code. So maybe the tact here would be to adopt the state ethics provision as is, and then add the personal benefit provision into our definitions of the ordinance. Mr. Brady, you were shaking
Yes,
your head.
Mr. Chairman, I'm just trying to take this in, and my thoughts are that I'm trying to find the difference between state law and the suggestions, and there may be some, but on first glance, or at least what I'm seeing so far, it seems like it's really just a matter of additional verbiage, and spelling out things more specifically maybe than they're spelled out in state law, but not really covering anything additional than is covered in state law. And I'm just trying to wondering, not having been on their committee, and wondering what they were trying to get at that's not in state law, because I'd probably be very much in support of whatever that is if I can find it. But all I'm finding is are sentences and additional verbiage that to me probably refers back to state laws that already exist until somebody points out the difference to me.
What we're trying to do, we have to, state law is the foundation. And so we take the state law, we have an opportunity, once again, to do only two things: enhance it or accept it as is. So that's what we're doing now. We just came up with the definition of full family that was not in state law. We also expanded the definition of immediate family, which was not in state law. So we may find, you're right, that a number of these definitions we will adopt as is. And most of them we would hope we would. But as we go through these definitions, and more specifically when we go through the actual policies that will be contained in the ethics ordinance, we may adopt what's currently here, we may expand on it. But it's a necessary, in my opinion, it's a necessary exercise to go through this so that we come up with, once again, people are going to come to us as being members of this committee and expect for us to have a working knowledge of what's in the ordinance that we present. So that's why I think it's important that we go through this. You're right. This definition.
I'm not suggesting that it's not worth going through.
Okay. I didn't imply
I'm
that.
just, commenting on the process as we go through it, and it's a sort of a needle in a haystack sort of an issue. It seems it appears.
Mr. Greenspan, these items that are listed on starting on page 6, and these are items then that you would have to list on your ethics form. You're not prohibited from taking them as long as you list them on your ethics form. Is that what you're saying?
Correct. And understand, we're not, as we come up with these definitions, the intent isn't to identify those items that are prohibited. The intent would be to further explain, the ethics, the ethics ordinance that the ethics law the state has also provides guidelines, as will ours, for certain items of financial disclosure. So even though this definition in itself, we're talking about the personal benefit definition, may not be applicable to, although it probably will be, to an ordinance, it does at least give a definition as to activity. I can't imagine. I'm not going to even try to elaborate on what a personal.
If your wife has a baby shower, then we got to put your stuff down. Maybe you get it for a baby shower. Like this.
I would, Mr. Morales, is that accurate? If my wife's having a baby in 2 months, if council provides a gift, would I have to disclose that as a gift from council?
Well, I'd have to think about that, but my immediate reaction would be that you probably should disclose any gift that you receive in the course as a public official. But that's certainly something that I would want to think about. The other thing I would point out is that these items that are listed on page 6 of 24, going into that also included the reference to anything of value. They are exclusions from the definition of personal benefit. So they're not listing examples of personal benefit. Rather, they are listing exclusions of what is intended to be meant by the definition of personal benefit right above. You'll see it says, however, the term personal benefit within the meaning of this ordinance does not include any of the following, which, although they may benefit individual public servants, are deemed to be primarily public benefits rather than personal benefits. And then there's a list of exclusions, 1 through 17.
I'd like to raise a couple of points, and on one of them I know I'm going to be a little bit of a pest, but I think it needs to be raised. The first point about anything of value is whether you're aware of, if in section 1.03 of the revised code that it refers to, whether it creates any exception for things that are of minimal value. So that something that, because I know as we get into this ethics law, there's places where it says you cannot accept anything of value in exchange for this or exchange for that, or that might influence this or that. Do you know if there's any exception made for things of minimal value?
That I do not. I do recall there being a definition of $75 or greater, and I'm not sure if it applies to this section or not. Regardless, I understand your point. We should know, but this is the current state law, so whatever it is, we have to abide by it. But to your point of not having knowledge of that, maybe Mr. Morales, if you don't know now, next week you can provide us with that definition.
I think it's less than $75. But what I was going to suggest is that where one of these definitions refers to a provision of the Ohio Revised Code that is not currently in front of the committee, I would be happy to research those provisions of the code and provide that information to you, so that when you're considering these things, you at least know what the reference means. So perhaps as a suggestion, if one of the definitions is referring to provision of the code that's not here, then maybe you pass over that and allow me the opportunity to get it for you, and so that you clearly understand exactly what it is you're addressing.
Okay, well, let me ask this point.
Mr. President.
Yes.
The second point that I was going to make is that I'm aware that when I fill out my financial disclosure form, that I have to report any gifts that I've received worth more than $75. But it says that you do not have to include gifts received from immediate family members. That being the case, if we use a broader definition of immediate family members, it actually has the impact of weakening what we're doing, and that could potentially be a problem.
I would think that the definition of immediate family as it pertains, there may be different definitions of immediate family from financial disclosure versus what the county adopts as its ethics ordinance. So it wouldn't, I don't know if it would weaken your ability or enlarge your population as to who you would need to list as gifts from or exclude people. Because we may have one definition, the state may have another. That's what gives us the authority to expand the definition of the. So in answer to your question, the state on your financial disclosure will have a definition that may not be equal to what our definition is. But our definition of immediate family, we didn't change. We just added domestic partner and added stepchildren. Now, if that document said full family, then I think I understand your point. Getting back to the definition of anything of value, we can do one of two things with that. We can take it as is, which is current state law, which effectively I think we're going to have to do anyhow unless we wish to strengthen it. Or we can table it till next week, as we will with the definition of public agency, until we get a definition from Mr. Morales. I'm not sure Mr. Morales' definition will impact our, today's vote if we were, or consent to move forward with this. But I'll leave it up to your feedback. I mean, is it something we wish to bring forward today, or do we want to wait until Mr. Morales gives us a definition from 1.03?
I think we ought to take the state law, because that's been probably litigated, at some length in various states and various, agencies. So I think we're safer just taking the state law.
Okay. Any?
I tend to agree, but if anyone has a suggestion, about what we would, what we might do to enhance this that would be, of some kind of positive benefit to the process, certainly open to that. I just haven't heard any suggestions like that.
Mr. Jones?
Mr. Chairman, I'm in agreement also with leaning towards the state law. Again, just from the fact that don't feel up to task at the moment to make any major changes. One concern I have is, or not a concern, but would like to know, are there any pressing issues that we need to tailor our county laws, county ethics laws to? Are there any pressing issues that we need to consider? I could see imagining, or at least discussing some of those things and what changes might be needed.
That would be a discussion. Once again, part of the framework today was to identify the definitions, and next week we would get into the specific policies. I know there's a hot topic, and I'm aware of the hot topic. We're not going to resolve it between now and next week anyhow. And I believe we're still waiting to get some legal opinion. Mr. Morales and I talked earlier today about this specific subject. I'll digress for 1 minute off this. I'll just make the statement, and I don't mean to not allow comment, but I'll give you an update on what Mr. Morales and I talked about and my conversation with the Ohio Ethics Law on this 124.57 issue. Basically, we don't have the authority to change that. The Ohio Ethics Commission basically stated it's a state law, you cannot weaken it. Mr. Morales, I think he and I talked, and generally, I'll let him speak on his behalf, but it unfortunately is a state law that was not enforced in the county. And that's what the Ohio Ethics Commission told me. That's what I spoke also today with the, with Personnel Board of Review. They confirmed that same decision. And Mr. Morales may have, looks like he's got to step away, may have a comment on that, but to the extent that we'll discuss that next week as more information comes in. But the preliminary discussion is we don't have the authority to overturn or to amend that state law. Now, just moving back onto the agenda here, anything of value. So, is the consensus to adopt what's currently here within the state law? Mr. Miller.
That is also my view, but I also think that the concept of anything of value is of really high importance for ethics code, and I think it's very important that we get the report back next week, and that we all have an understanding of exactly what that state code says, so that we know what we're talking about in that regard.
Okay. Well, let's do this then. On this issue, we will hold consensus today till we hear back from Mr. Morales, because we may want to strengthen it. We obviously realize we can't weaken it. Unfortunately, he's out of the room for me to. The next definition will be honorarium. I only find two references to honorarium, one in the state code and one in the transition advisory definitions. I'll read the state code definition, then the transition advisory group's definition. Honorarium means any payment made in consideration for any speech given, article published, or attendance at a public or private conference, convention, meeting, social event, meal, or similar gathering. Honorarium does not include ceremonial gifts. There you go, Alan. Or awards that have insignificant monetary value, unsolicited gifts for nominal value, or trivial items of informational value, or earned income from a person or other than a legislative agent or personal service that are customarily provided in connection with the practice of a bona fide business. If that business initially began before the public official or employee conducted that business was elected or appointed to the public officials or employee's office or position of employment. That's the definition. That's state law. Here is the transition advisory group. It's more condensed. It may cover the same thing. Payment of money or anything of value, directly or indirectly, to an elected or appointed county official or employee, or to any other person for his or her benefit, as consideration for speech, a presentation, or a written document that relates to the official or employee's county position. What is not in, and this is my own commentary, what is not in the state's definition, that is in the transition advisory group's definition, which I happen to like, is what's in parentheses, or any other person on his or her behalf. And I believe we're within our right to add that language. Basically, what this does is it basically says and this happens all over the place, where somebody will say, well, if you vote my way, I'll make a donation to your church, or I'll do something, something along the, religious affiliation, to an organization that, or a philanthropy that you have a relationship with. So you're not directly benefiting, but somebody else is as a result of your vote or your action or your position of authority. I would suggest that we would consider adding that language to the state's language, which I believe is more encompassing, that would provide more teeth to the definition of honorarium.
Mr. Chairman.
Mr. Brady.
I don't have any objection to the additional language. Again, I get concerned that we start to stretch out into, almost any aspect of anyone's life, and I guess this is all about what your intent is in any given situation, which may not be that easily determined. But with laws like this, your intentions could be inferred in a way that they were not intended. About 15 years ago, there was a significant scandal in state government around honorariums, and involved people at the highest levels, Speaker of the House and President of the State Senate. And I know at that time a lot of this was reviewed, and so I would expect that a lot of a need to tighten up those laws is reflected in state law following that scandal 15 years ago. I have no opposition to the additional language, just the concern over the creeping, as I'll call it, definition of what a person may or may not do, because again, this is about what a person's intentions are, and I'm really reluctant to lean toward criminalizing every kind of interaction that any public official may have, which I think we're not getting something I'm concerned about, because I believe that a lot of the way that we discuss politics and government gets close to criminalizing politics, and which is it's understandable given what the county's been through, but at the same time is it also the heart of our ability to interact as citizens in a democracy. And so some kind of a balancing act certainly has to be acknowledged.
Now, excuse me, are these honorariums that we are just listing or prohibited? You're saying anywhere the word honorarium is used, this will be the definition. Is that what you're saying?
Correct.
It's not prohibited from accepting an honorarium as long as it comes.
It depends how the policy, what the policy says and how the policy is written. If it's the disclosure of any honorarium, yes, that's what we're talking about.
Oh, okay. Because you go out and deliver. If I live my other life as a historian, go out and give a speech that I've prepared and receive an honorarium for that, and that should not be criminalized. I think was what Mr. Brady's saying.
And that's not the intent here. That's not the intent of the current state law. The only thing we're talking about right now is, first of all, we don't have a choice. This is the state law, so we have to adopt it. The question is, do we want to add in here or any other person on his or her behalf? That's really the only discussion we have right now. I would be in favor of adding that language. I'm trying to determine in the current state law where we would need to add it. Once again, I believe it's under the definition of strengthening, not weakening. So my inclination would be to add, as the Transition Advisory Group recommends, that language. Is there any further? Well, Joe, you're taking this down. Give me 1 minute to read and find out within this definition where we would need to add that. If let me read this as I believe we might want to modify it. Honorary means any payment made to or, well, here, to, how do we define this here? To a public official or employee. Once again, we'd have to get down to defining what a public official and employee are. Public official and employee, means a payment made to a public official, employee, or to any other person on his or her behalf in consideration for any speech. Does that language sound fair? I'm sorry.
You're already going to have to put all this on your ethics form if you receive some compensation for delivering a speech. So, it's already a public record.
If you do. But if you don't personally receive, by adding this language, any person or persons on your behalf, actually we might want to expand it to say any other person, organization, or entity on your behalf. This would, let's say on the Council President Connolly that you made a speech.
I give a speech and I tell them to give $5,000 to the Breast Cancer Fund of Ohio.
Right now, you don't have to disclose that because you didn't personally receive benefit from it, but an organization that you did as a result of your actions. So that's what's being said here, because you may say, make this donation to, I'll give you an example. I might make a speech and say, give that $5,000 to the Beck Center for the Arts in Lakewood. Well, my wife's the chairman of the Beck Center. So there would be, that's why it would need to be disclosed. Right now, there's no disclosure that needs to be made. All this says is this language would further add that you just need to disclose if it was made to any person or entity or organization on your behalf. That's all we're saying.
But you're not getting any credit for that. The Beck Center, which is a nonprofit organization, will have to disclose the source of that income. Who's hurt by you doing that?
I don't think it's an issue of who's hurt, but you're assuming that an organization would disclose that information. I could say make a donation to a political party. I could say make that disclosure to an entity that doesn't have to report. So all this does is say, just tell us if you did something and the benefit went to someone else, then just disclose who that is.
That's fine. It's fine.
Okay. So
I'm sort of playing the devil's advocate here.
that's what this process is for. I completely respect that. So, Mr. Nani, are we good with that? Persons or entities, I would.
But if you just say you made a contribution to the Beck Center because you spoke somewhere, They're not saying that Dave Greenspan is now how you get to be like a upper level club member. You just gave the contribution. You're not getting any benefit from that.
No, but the organization is as a result of my public being. If I'm asked to speak as a member of council and there's an honorarium attached to it, all this is saying is just disclose that you gave the funding away.
But you're saying if you gave it as a member of council, I go out as a private individual and speak because I guess I'm no longer a private individual. And I say, I'm going to speak some places, I can't accept the money. Okay, yesterday, I spoke at a church, they wanted to give me $200. I said, I can't take the money. I said, just give it back to the scholarship fund or whatever. I don't know what they did. I didn't get anything out of it. So do I have to disclose that under this?
Because you didn't, in my opinion, you didn't direct them to put that money toward, you just denied it. But if you had said put it towards your youth scholarship program.
Well, I just told them to give it back to the scholarship fund that, it was coming from.
I wouldn't think there's an issue with that. But if you were to direct that specifically to another organization, that's just my opinion on that. I don't, all this says is if you do something as a result of your public office, and whether you accept the money or not, just tell us, disclose, because I'm sure this is going to be a disclosure item on a financial report, that you spoke at X event, you directed them to pay the honorarium fee to an organization or an individual or to something else. That's all it says. It's purely a disclosure. Oh, I didn't know if there was a comment. Okay. Okay. Yeah. Yes.
Mr. President, Chairman, I was just pointing out that that in the Ohio legislature, the honoraria were not just a matter of disclosure; they were prohibited. So I don't know what our policy will be here, but that's what it was there.
Well, and we'll continue to go through the state law and determine where it comes from. I would say whether you take the money or not, assuming it's money or a gift or what have you, whether you take it or you direct them to pay somebody else, it still needs to be disclosed or is a prohibited activity. That's just my and I'm assuming that's the interpretation of it. I keep looking to Linda Mayer, who's chair of the Transition Advisory Group on Ethics. I keep looking to Linda to just to make sure I'm interpreting that correctly. But if I'll allow. Okay. Sure. Mm-hmm. Okay. Mm-hmm.
But you don't have a problem if I gave a speech and I said, you know what, I can't accept the money, but if you'd like to make a contribution to the Breast Cancer Fund of Ohio, that'd be fine with me. So that would be okay with you.
Yeah, and that's all this is, just disclose. When it comes time to disclose it, just disclose it. Right, and that's not what this is trying to say either. Just defines that if you don't get it, don't think you don't have to report it, even though you designate it go to someone else. Right.
Mr. Chairman, on this point, I have to admit I appreciate in terms of the transition committee's recommendations, I appreciate the clarity that can quickly be brought to bear by someone who's here representing the transition committee, because I'm just trying to define it myself, and probably not always in the right way, or may not even be on the right track. So, thank you.
Thank you, Ms. Mayor.
And Ms. Mayor, could you, just for my benefit, say what you were trying to prohibit?
Why don't we do this? Because we've been sitting here for 2 hours. Why don't we take a 5-minute break? Oh, no? Okay. Well, let me ask this then. Let's go till 3:15, and then we're going to have to modify the schedule because obviously we didn't get through everything we wanted to. We'll go as far as we can till 3:15. We'll be back here at 4 for a meeting. Before we adjourn, we'll set the next meeting. I think we may have to meet before next Tuesday, so we can keep on track. I don't want to push us back. We're run up against. Find out that in March we're scrambling to get this done by the 22nd before the current ordinance expires. And then I would ask that in between now and when we decide to meet again, that we go through, each of us individually go through this exercise and come up with suggestions so that we're here at our next meeting. We're a little more engaged in what we're now the process has been defined, and I appreciate this is as nitty gritty as it gets, in my opinion. But this is, I think, so needed, especially with what's gone on in this county so far. All right, let's continue on. So honorarium, were we in agreement to add those words to the current state law? Okay, Joe. So Joe, you've got that? Yeah, you want to
read it again? Is the definition of honorarium includes any payment made to a public official or employee or to any other person, persons, or entities on his or her behalf. Does that cover what you guys?
I believe it did.
Okay.
Yep, Mr. Miller.
I think there's one thing that's embedded in the state language that needs to be carried over that I didn't hear, where it says honorarium means any payment made in consideration for any speech, etc. So that there has to be a clear relationship that it's some kind of compensation.
Meaning take that language straight out of the definition and drop it in there. Okay.
Absolutely, thank you. One thing, Mr. Morales, kind of backtracking a little bit. In the definition of anything of value, what council would like is the definition from 1.03 of the revised code, so we know what that value is. If you could present that at our next meeting,
Okay.
that would be helpful. Moving down to the word employer. Employer means any person who directly or indirectly engages an executive agency, lobbyist, or legislative agent. Let's go through and identify the word employer. I'm not aware, Mr. Jermaine. Have you found any other definition for employer? I have not. Once again, if we find, as going through further discussion, that we are made aware of a definition that we skipped, we can go back and modify it. What we're doing today doesn't etch it in stone. It just starts us down the process. If I'm not aware of anything, I didn't see anything in the Transition Advisory Group or the other document. If there's nothing else, then I would recommend that we adopt the current state definition of employer. Any discussion? Hearing none. Okay, that's adopted. Executive agency decision, executive agency lobbyist, and executive agency lobbying activity shall have the same definition of meaning as 121.60 of the revised code. What I would recommend as well, Mr. Morales, could you, if my colleagues are in agreement with this, if you could provide us with what that definition is at the next meeting, that would be beneficial. Are we in agreement with that? So at least we know what that definition is, since they refer to an ORC section. We'll do the same thing with legislation, because it looks like it does the same thing with K. So J and K, Mr. Morales. You're going to be happy when you have staff, aren't you?
Yes.
Moving on, expenditure has the same meaning in the section when used in relation to activities of a legislative agent, the same meaning in these code sections. These look like they're starting to get pretty technical with the definitions. And actually, I believe this is the last definition in this section of the Ohio ethics law. Mr. Morales, why don't we ask the same thing of you for L as well? So you've got G.
And Mr. Chair, there's a question.
G, J, K, and L. Yes, sir. Oh, Ms. Mayor, I'm sorry. They're all throughout, right? I'm just referring to this. Correct. No, I understand that. I was just looking at this page as it related to 102.01. Correct. What I was going to recommend now, since it appears we're at a stopping point, at a clean break, that we take that break to recess to another time, so we can prepare for the meeting at 4 p.m. And then we'll pick this back up. What I would recommend to my fellow committee members is that please review the definitions that are in here, so that when we do adjourn again, that we do meet again, that we will be able to move through this a little quicker. But understand at the same time, this may be the most critical part, I believe, in what we do, because once again, it does build the foundation. With that said, I have proposed a meeting schedule. The next time we would meet would be next Tuesday, I presume at the same time. Oh, it is next Tuesday? Well, let's do this. Let's be here by 1.
Just because I know we're going to have this discussion coming up very quickly on the confirmation hearings, will any of this be? We have to make sure we're not in conflict with these confirmation hearings as well. I realize this isn't going to be easy, and I, for one, think that we're probably going to, spend a lot of time down here this winter. I don't see any way around it, actually.
I had set the confirmation hearings tentatively for Thursday. It's on the agenda.
Okay.
I think the first one I set for the sheriff was Thursday, the 27th at 10.
Right.
And then,
right.
Well, wait a minute. No, actually, I did say that we were going to do like Thursday, Tuesday, Thursday.
Going forward after the 27th,
right,
correct?
Right. Mm-hmm.
All I'm saying is the obvious. The coordination of,
may have some
coordination of
conflict
these
with
committees is going to be...
Unless we can stretch the confirmation house just to Thursdays. We can talk about that at 4 o'clock.
Sorry, excuse me.
That was
looking at the calendar for this week, I'd like to, and we can determine next Tuesday what we want to do with that meeting, if we want to move it to a different day. But I think we should have one more meeting this week to hopefully get the definitions cleared up. Looking at, we have to give 24 hours notice, so tomorrow's out. Looking at Thursday, is there any conflict with Thursday at 1 o'clock or Thursday at 2 o'clock?
I could probably do Thursday at 1, although I really can't say, because I talked to Jean this morning, and the information for the agenda, and she'll be explaining this at the meeting at 4 o'clock, the agenda items for the council meeting for Tuesday have to be in to her by Wednesday at 4. And then she has to work on the agenda, and I guess I have to do some work with her in terms of which items are going on the agenda. And then council, we're going to have to talk about that also, where council is going to have to be looking at those agenda items and where they're going forward and stuff. So I might have a conflict, but if Ms. Simon can be here, other people can be here, I can probably work it out. So why don't you go ahead and set it?
Do we have any other conflicts Thursday at 1? Thursday at 1? No? Okay, so we'll set it for Thursday at 1. And let's, with the expectation we'll be able to get through the definitions and next week start discussing the actual legislation, the actual policies themselves. Joe, will you ensure that we do a public
Yes.
notice? The agenda, I'll come up with the agenda and get that to you so we can publish that as well. A few other things real quick before we leave. That falls somewhat under this committee's just purview. We need to have a sunshine law training the elected officials do pursuant to state law. What I'd like to do is ask George to assist in no dates for that training from the state attorney general have been published yet. So what I'd like to ask him to do is put together a schedule so that we can all attend as quickly as possible.
They told me that they would come down and do it. We don't have to go there. They'll come here and do it.
Okay. Did they give us any dates or times yet?
I can't think of the lady's name. I talked to her about a week or so ago, and they said because of the nature, we're a new body and all that, it's about an hour and a half train. So they said they would come here.
Do we maybe want to do that before a council meeting? When we're...
I would think some Tuesday, probably going into February or March or somewhere in there. Give everybody enough lead time.
Okay. So you and Gene are working on that already?
No, I haven't. But I got to find the lady's name and all that. But
okay.
But Joe can. We'll give it to Joe.
I can coordinate that with you and George and just get something scheduled for Tuesday in February.
The other thing, and President Connolly, you may be the lead on this with your relationship with the archivist. We need to develop a records retention policy. I
heard Jean saying something about she was going to a meeting about that today. So we actually, if you want to put that under miscellaneous business at 4:00, we can bring that up today. Yeah.
Okay, my recommendation would be that we would have a presentation by the Records Commission archivist to come speak before this group, but if you don't think that's necessary, that's fine.
My understanding, maybe Mr. Morales can tell me, the archivist and the records retention are a different span, different groups.
She may have an expertise in the development of records retention policies, but I think that I certainly could help you with that myself, if you wanted.
There's also a records retention board that I think she sits on. I can't remember who else is on there. And the way it has worked in the past is that local board approves the records retention policy of each department, and then it's sent to the Ohio Historical Society for filing and review. So most agencies of the county that existed before have policies, public records policies, that have been approved by that board and are housed in Columbus in the Historical Society. But Judy can probably explain that process and how it would work.
Yeah, and maybe, President Connolly, maybe this afternoon, as part of the agenda, we have the sunshine laws and then this records retention discussion. Jean can provide us more detail. Yeah. And the last item is the open meetings policy. Remember, the ACLU sent that letter discussing the open meeting policy that we must adopt. And
we already adopted one at the first meeting.
Joe,
didn't we adopt that at the first meeting? We have a procedure that the 24 hours and post it on the website. I think we've been pretty diligent about it up until this point, so I don't think we're going to...
Joe, are we required by state law? I think we are required by state law to adopt an open meetings policy. No. Okay. Mr. Morales, do you know anything about that?
At a minimum, it's a best practice, right? To have a policy, and certainly the law does require public agencies to have public records policies, and
public records and open meetings.
Yeah. Yes, policies pursuant to the Sunshine Act.
Would you be able to find out a best practices policy that we can consider?
Yes.
Okay, thank you. You and your staff of you?
Right.
Okay, great. With that, yes, sir.
I'm sure the AG has a model policy that we can.
On that point, we adopted a number of procedures into our rules that create various kinds of specific notice requirements, all of which meet or in some cases exceed what's required. And I would suggest that if we prepare a policy that it should track and restate those specific requirements that are embedded in our rules of council.
Okay, very good. So, Mr. Morales, it's not going to hurt for us to have the policy. And so as Councilmember Miller said, let's include what we've already adopted. I'm sure it far exceeds the minimum requirements. One other note, this committee has a number of things time sensitive we're going to need to work on. We do have rules that expire on March 22nd as well. They're not going to be as in-depth as this. Dale has done a great job in vetting those out, but there are some modifications we'll need to make. So I would envision maybe Councilmember Miller, maybe 2 meetings to really vet out whatever issues have come up there. We also are going to need to discuss the Inspector General in that process. Not I would assume not before March 22nd, but those are some items that are going to come, I would imagine, under this board. And some of these policies that we just discussed that make recommendations to council, because I believe they would fall under either council operations or ethical practices of the county or both. So just keep that in mind, and I'll be sending meetings out. I appreciate your patience today. These 2 meetings, I believe, would be probably the most mundane of our meetings, and then we'll be able to get in some of the discussions. If there are issues that you want to discuss, like 124.57, please send them to me and we'll add them to the agenda. And I'll prepare the agenda by tomorrow so we